Hi, it's Bernard Nomberg with the Nomberg Law Firm in Birmingham, Alabama. And I wanted to take a few minutes to talk about, in the Social Security disability context, when you're appealing your case and you have an upcoming date for a hearing with the administrative law judge, there's a fairly new concept called the 75-day waiver. I want to talk about that for just a minute, and I've got some notes here to share with you. What is the 75-day waiver, and why is it important? Why should you consider it? Well, it's potentially a way for the Social Security Administration to offer you a hearing sooner rather than later. There are benefits, but there are also some things to really concentrate on. And what they will do is the Social Security Administration will send to you this document asking you if you'd like to waive the 75 days notice that typically is issued. And when I say notice, giving you a heads up, so to speak, about that your hearing will be 75 days or more out. This waiver allows you to make a decision whether you'd like to have your hearing heard sooner rather than later. And it does take consultation with your representative, whether it's an attorney or someone else who's helping you make those decisions. The 75-day waiver this deals with Social Security Administration's policies that they've got to give you at least 75 days notice before the hearing. But this waiver form, if you sign it and send it in, it's your way of telling the Social Security Administration that you give up that 75-day notice and you allow the Social Security Administration to hopefully schedule your hearing sooner than that 75 days. It could be 50 days, 60 days. It really just depends on the office that's going to hear your hearing and how busy that they are. They want to fill those time slots. And right now, there are no hearings in person until at least into 2021. So a lot of these are almost exclusively being done on telephone. The benefit is you get your hearings heard sooner and you might get a decision sooner. Well, who are the types of individuals who may need or consider that? Well, if you have a terminal illness, if you're homeless, if you have completed all of your medical care and that you're pretty confident that all of your medical records are on file with the Social Security Administration, or if you're just in dire need of assistance and these benefits would greatly help you. Those are the people who should consider it. Now, let's talk about what are some of the detriments, what are maybe potentially some of the fallbacks about waiving that 75-day notice. Well, sometimes healthcare providers, doctors, hospitals, clinics, wherever it is that you've got medical care, sometimes they don't get the medical records prepared and sent to you or sent to the administration in a timely manner. There's that 5-day rule where all evidence has to be in at least 5 days prior to the hearing with the ALJ. And a lot of times, medical clinics, healthcare providers, etc., they use services, third-party services, that may cause a delay. So that's one thing. You might be still in the middle of medical care, and that's a good percentage of your evidence. If you haven't completed a certain amount of medical care to show consistency about the issues that you're stressing in your claim for Social Security disability benefits, that may be another consideration. Regardless of your situation, if you're considering signing this waiver, you really should consult with your advisor or your attorney, whoever is helping you, your representative in this matter. Please stay tuned or come back to this channel for further videos on Social Security disability, workers' compensation, personal injury, and bankruptcy.